Criminal Procedure Code regarding jurisdiction of the criminal courts in inquiries and trial. You are aware that a criminal court is constituted for a particular local area. Previously we have discussed. So, ordinarily, a criminal court is competent to try the offence which is committed within the local jurisdiction of that court. So, section 177 of the CrPC provides ordinary place of inquiry and trial. Every offence shall ordinarily be inquired into and tried. Every offence, ordinarily, this is generally, be inquired into and tried by a court within whose local jurisdiction it was committed. So, section 177 makes it clear that ordinarily a criminal case is to be inquired or tried by a criminal court within whose local jurisdiction that offence was committed. This is section 177. 178 provides place of inquiry or trial when it is uncertain in which of several local areas an offence was committed. First, it is not clear under whose local jurisdiction a particular offence was committed, or where an offence is committed partly in one local area and partly in another. Suppose partly an offence is committed partly in one local area. Somebody was kidnapped from a local area of a particular court to another local area. Or similarly, suppose partly committed and partly committed. A girl was kidnapped from the local jurisdiction of a particular court and she was raped in the local area of another court. In such case, that is, this is where an offence is committed partly in one local area and partly in another. Third, where an offence is committed continuing one. The offence is continuing one. What is continuing one? That is continuing and continues to be committed in more local areas than one. Continuing one. The offence is going on, continuing, and that continues from one local area to the jurisdiction of another local area, or even it consists of several acts done in different local areas. That offence consists of several acts done in different local area. It may be inquired into or tried by a court having jurisdiction over any of such local area. Any of such local area. Continue one from one local area to any of such local area. Partly one offence was, that is, acts, several acts done in different local area that may be tried by court in any of the local area in which such act was committed, or when it is uncertain in any of the certain, whether within local area of particular court or within local area of another court. It is not certain. It may be tried in any of the court of the local area. That is section 178. Well, so, place of inquiry or trial. Every court has this local jurisdiction, that is territorial jurisdiction. We say that is territorial jurisdiction. So, when it is uncertain, within which territory, ordinarily, previously we discussed, 177 provides, ordinarily, the case is to be inquired or tried by the court, by the criminal court, under whose local jurisdiction a crime is committed. For section 178 provides that when it is not certain under which local area a particular offence was committed. In such case, that can be inquired or tried by any of the court. Second, where offence is committed partly in one local area and partly in another local area. In such case, that offence may be inquired or tried by the criminal court of any of the area where it was committed. Similarly, where an offence is continuing one and continues and goes on, that from one local area to another local area, that may be tried by the court in any of the local area when that offence, where that offence is continuing. Where it consists of several acts done in different local area, that is also, that can be tried or inquired into by any of the courts by having jurisdiction on any of such local area. 179. Offence triable where act is done or consequence ensue. Where an act is done, where act is an offence by reason of anything which has been done, and of consequence which has ensued. Act is done, part and what is done, and the consequence of that ensued within the law. Act is done within the local area of a particular group, and the consequence of that act that occurred in the local area of another. In such case, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has ensued. Suppose somebody is sustained within the local area and thereafter he died within the local area of another court. Here what it says, where an act is an offence by reason of anything which has been done and of a consequence which has ensued. The act done is an offence, the consequence that occurred, that is an offence. But the consequence that is also an offence. The offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has arisen. Ensure, particularly if there is a kidnapping, suppose your act was done, that is an offence. There, that consequence that kidnapping, something happens in the local area of another court. That court also gets the jurisdiction to inquire and try that offence. Section 180 provides place of trial where act is offence by reason of relation to other offence. An act is offence because of relation to other offence. So in such case, similarly, concurrent jurisdiction is available to both the courts. This is called concurrent jurisdiction. So what it says, where an act is an offence by reason of its relation to any other act. Suppose some stolen property was recovered. That stolen property is an offence because of consequence, because in relation to commission of a theft. So where an act is an offence by reason of its relation to any other act, which is also an offence, or which would be an offence if the doer were capable of committing an offence, the first motion that will be the doer, that the offender committed an offence, the first mentioned offence may be inquired into or tried by a court within whose local jurisdiction either act was done. Act was done. Because of that act, another act is an offence. When an act is an offence, by reason of its relation to any other act. Suppose this is stolen property. Somebody is possession of stolen property here in Bhubaneswar. Another that is a theft was committed there in Cuttack. So because of the theft that was committed in Cuttack, possession of stolen property is an offence. That may be tried either in either of the courts. The section 181, place of trial in case of certain offences. There are certain offences where in which place such the trial for those offences will be conducted, will be done, will be made. But it says place of trial in case of certain offences. Any offence of being a thug or murder committed by a thug. A thug or a committed by a thug. What is thug? Do you know who is a thug? That is section 400, perhaps 15. Who is a thug? That is, so if a person is a thug, who is a gang of robber, so in such case, if the offence of thug or murder or of belonging to a gang of dacoity, or of escaping from custody, that may be inquired into a trial by a court within whose local jurisdiction the offence is committed or the accused person is found. It is very important. Suppose there is a dacoity. In such case, the offence may be tried by the court within whose local jurisdiction the offence was committed, or the Dacoity was found. Even a thug, if the offence of thug, that is where the offence was committed and where the accused was found. Similarly, a dacoity with murder, when there is a dacoity with murder, such offence may be tried by the court within whose local jurisdiction that dacoity was committed or the accused was found. Gang or dacoity, escaping from custody. Somebody has escaped from custody. So, offence may be tried by the court from whose local jurisdiction that person escaped or that person was found. This is section 181. You should remember it that certain offences, that is offences of thug, murder, committed by a thug, dacoity or dacoity with murder or murder or belonging to a gang of dacoity, or escaping from custody. So such type of offences may be tried by a court within whose territorial jurisdiction, the local jurisdiction that offence was committed or the accused was found. Subsection 2 says, any offence of kidnapping or abduction of a person, kidnapping or abduction of a person may be inquired into a trial by a court within whose local jurisdiction the person was kidnapped or abducted or was conveyed, within whose local jurisdiction that person was conveyed or concealed, even that person was concealed, so the kidnapped victim was concealed somewhere. That court can also try that, inquire and try that offence, or detain, somewhere he has detained. This is peculiar provision. In case of kidnapping or abduction, the offence may be inquired or tried by the court from whose local jurisdiction the offence, within whose local jurisdiction the offence of kidnapping is committed, or the kidnapped person was conveyed or concealed or detained. This is subsection 2. 3 says, any offence of theft, extortion or robbery may be inquired into a trial by a court within whose local jurisdiction the offence was committed. This is ordinary place. Extortion, theft, robbery, that may be inquired or tried by the court within whose local jurisdiction that offence was committed, or the stolen property which is the subject of the offence was possessed by any person. The person who is in possession of the stolen property, where it can try committing it, or by any person who received or retained such property knowing or having reason to believe it to be stolen. Such offences may be tried within whose local jurisdiction that offence was committed, or from within the local jurisdiction of the court where the property of the theft, extortion, robbery was found. Similarly, any offence of criminal misappropriation or criminal breach of trust. When offence of criminal misappropriation or criminal breach of trust is committed, that may be inquired into trial by a court within whose local jurisdiction the offence was committed. It is ordinary within whose local jurisdiction the offence is committed, or any part of the property which in the subject of it was received or retained. Any part of the property which has been obtained by criminal misappropriation or criminal breach of trust, if that was received anywhere, if the jurisdiction of some other court, that property was received or retained or was required to be returned or accounted for, where such property within whose local jurisdiction that property was to be required to be returned or accounted for by the accused person, by such court, those offences can be. What is that? Any offence of criminal breach of trust, criminal this misappropriation, those offences may be inquired or tried by the court under whose local jurisdiction such offences are, or by the court if any part of the property which is subject of the offence, subject of such offence, was received by that court or retained or was required to return by the court within which local jurisdiction such property would have been returned or accounted for. Third, any offence which includes the possession of stolen property may be inquired into a trial by a court within whose local jurisdiction the offence was committed, or the stolen property was possessed by any person who received or retained it, knowing or having reason to believe it to be stolen property. These are all concurrent jurisdiction. This section 181 makes certain provision. Then under section 182, offence committed by letter, etc. Any offence which includes cheating may, if the deception is practiced by means of letter. For every cheating there will be deception. If the deception is practiced by any means of letter or telecommunication message, deception is practiced by telecommunication message, will be inquired into or tried by a court within whose local jurisdiction letter or message was sent. Such message or letter was sent, that court has jurisdiction, or were received, under whose local jurisdiction such letter was received, a telephone message was received, that court can do. And any offence of cheating or dishonestly inducing to deliver property. Cheating and dishonestly inducing to deliver property may be inquired into or tried by a court within whose local jurisdiction the property was delivered. Property was delivered by the person received or was received by the accused person. Any offence punishable under section 494 and 495 of the Indian Penal Code, that is, may be inquired into trial by a court within whose local jurisdiction the offence was committed, or the offender last resided. Offender last resided within his or spouse. This is 494 offences, that is bigamy. Bigamy 494, that is offence of bigamy. 491 offence which concealed a former marriage from person with whom subsequent marriage is contracted. That 494, that is marrying again during lifetime a husband or wife. That is, it is by bigamy. In such case, what happens? Any offence punishable on section 494 and section 495 of the Indian Penal Code may be inquired into or tried by a court within whose local jurisdiction the offence was committed, or the offender means the person was committed the offence, last resided with his or spouse by the first marriage, or the wife by the first marriage has taken up permanent residence after the commission of the offence. These offences can be tried by all these courts. 183, offence committed on journey or voyage. Sometimes, suppose a person is on journey in a train from a particular destination to another destination. That offence is committed. A person boarded in a train from Cuttack station and went to Delhi. There he found that his belongings had been stolen. Then which court will try that offence? What it says? When an offence is committed, while the person by or against whom or the thing in respect of which the offence is committed, while the person by or against whom or the thing in respect of which, that means suppose a person was attacked in a train. So here somebody attacked was by or against such person while he was in journey. So when an offence is committed while the person by or against whom or the thing in respect of which the offence is committed is in the course of performing a journey, or voyage, the offence may be inquired into or tried by the court through or into whose local jurisdiction the person or thing passed in the course of his journey or voyage. That means the course within the court, any of the court that can try during which local jurisdiction that person or thing passed in the course of journey. So when an offence is committed against a person or against a court or in respect of a thing in respect of which the offence is committed, such offence may be tried by a court through or into whose local jurisdiction that person or thing passed through. This is the provision that is under whose local jurisdiction the trainer passed, or that thing or that person in the course of journey or voyage were passed. So this is section 183. 184, place of trial for offence triable together. There are certain offences when some offences are to be tried together. The offences committed by any person are such that he may be charged with and tried at one trial for each such offence by virtue of the provisions of section 219, 220 or 221, or the offences committed by several persons are such that they may be charged with and tried together by virtue of the provision of section 223. The offence may be inquired into or tried by any court competent to inquire into or try any of the offence. But to understand the provisions of section 194 of the CrPC, 184 of the CrPC, you should know that when there will be joint trial, or framing of joint trial, or framing of joint charge, that is, there is provision in section 219 and 220, 220 and 221, and section 223 of the criminal procedure. We will discuss those provisions in later while discussing about the charge, but you should have some idea about those provisions. In such case, this offence may be required into a trial by any court competent to inquire into or try any of the offences. The section that is section 219. You arrive at 219, section 219 of the CrPC provides 3 offences same kind within a year may be charged with. While framing a charge, 3 offences of same kind may be charged together. Where a person is accused of more offences than of the same kind. If a person is accused of offences, accused of committing offence of same kind, within the space of 12 months, within a period of 1 month, from the first to the last of such offence, whether in respect of the same person or not, whether in respect of the same person, he may be charged with and tried at one trial for any number of them not exceeding 3. So that's section 219. So when a person is facing trial, that is 3 offences of the same kind committed within a space of within a period of one year, by an accused, whether that is committed within the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 3. Suppose a person is facing trial for committing theft. He committed one theft here within the jurisdiction of local jurisdiction of Kotak, and another within the local jurisdiction of Bhubaneswar, another within the local jurisdiction of Puri. So here, this section 219 says, where a person is accused of more than one of the same kind of committed, same kind committed within the space of 12 months, so he may be tried by only one trial. There can be tried at one trial for any number of offences. But here section 184 provides, but says the offences committed by any person are such that he may be charged with and tried at one trial. That is, the offences of the same kind. Those offences of same kind he committed within a space of 1 year. So in such case, this offence committed by any person that can be tried together as per the provision section 219 of the CrPC. Similarly, so in such case, the offence may be inquired into or tried by any court competent to inquire into or try that. Both the theft are committed within the jurisdiction of Bhubaneswar or Puri, because he is facing trial for the 3 offences, that may be tried by the court, by any of the court. That is provision. Similarly, this is 219, 220 also, with such a provision, trial for more than one offence. In one series of acts, so connected together as to form the same transaction. More offences than one are committed by the same person. He may be charged with one trial at one trial for every such offence. Where a person charged with one or more offences of criminal breach of trust, dishonest misappropriation of property, this is section 220, there will be a framing of charge, joint charge. This also provides, if such a joint charge can be formed, so such offences may be tried or inquired within the local jurisdiction of any of the court, to be inquired by trial by any court competent to inquire into or try any such offence. 180. Power to order, prior to enter, that is, order case to be tried in different session division. What it says? Section 185 gives power that to the state government to direct that a case or a class of case may be tried by any district, may be tried in any sessions division. For every district is a session division. What section 185 provides? Notwithstanding anything contained in the preceding provisions of the chapter, not considering, not into taking into consideration any of the provision preceding in the chapter, the state government may direct that any case or class of cases committed for trial, once a commitment has been made for trial case in any district, may be tried in any sessions division. So this power is given to the state government, may direct that a particular case which has been committed to a session laws, committed for trial in any district, may be tried in the session division by another district. Provided that such direction is not repugnant to any direction previously issued by the High Court or the Supreme Court. If the previously the High Court or the Supreme Court are given any direction for trial of a particular case by any particular court, then in such case, the state government cannot make cannot direct that a particular case be tried in another session. Why such a provision is there? Sometimes, suppose there are some heinous offences are committed in a particular local jurisdiction of a particular session, a particular district. There may not be, when trial of the case may not be in a fair trial because the witnesses may be threatened in that particular case. Suppose, say for an example, in a particular local jurisdiction, an offence of murder was committed. The witnesses are afraid of to come to that particular court because the accused persons are the influential persons of that locality, they may threaten. So in such case, the state government may direct that case, that sessions case, may be tried, were committed to district means a sessions trial case, may be tried in another session. Such a power is available to the state government, but such direction will not repugnant to any other direction if previously given by the High Court regarding the same. Section 186, High Court to decide in case of doubt, district where inquiry or trial shall take place. In certain case, there may be a doubt within which session division or a particular case is to try. In such case, who will pass order? Where two or more have taken cognizance of the same offence. Two or more courts, concurrent jurisdiction, thinking or believe, or that holding that there is concurrent jurisdiction. Two or more courts have taken cognizance of the same offence. And a question arises as to which of them ought to inquire into a trial of the that offence. Suppose two or more courts have taken cognizance of the offence. And in a question arises as to which of the court will inquire or try that case. In such case, if the courts are subordinate to the High Court, by the High Court. If both the courts are subordinate to the High Court will pass order by which court such offence is to be inquired or tried. If the courts are not subordinate to the same High Court, suppose one court of Odisha has taken cognizance and another court which is adjacent to that court of another state has taken cognizance of it. And it is doubtful, then a doubt arises, then it is not clear. The question arises as to which of the court will try that offence. Then in such case, if the courts are not subordinate to the same High Court, by the High Court within local limits of the jurisdiction, appellate criminal jurisdiction, the proceedings were fast commenced. The proceeding, the criminal, which of the court who has taken first cognizance of the offence, that with the High Court under whose local jurisdiction, under whose jurisdiction that court is coming, that High Court will pass an order, which court will inquire or try the offence. And thereupon, all the proceedings in respect of the offence shall be discontinued. If the High Court passes an order that any one of the criminal court will inquire and try, then on passing of such order, then the proceeding of other court will be discontinued. Power to issue summons warrant for offence committed beyond local jurisdiction. If beyond local jurisdiction of a court, an offence is committed, then magistrate has some power. Where a magistrate of the first class, she is reasoned to believe, magistrate of the first class, she is reasoned to believe that any person within his local jurisdiction has committed outside jurisdiction, whether within or outside India. The magistrate first class has reason to believe that a person has committed an offence outside his local jurisdiction, either within India or beyond India. An offence which cannot, under the provision of section 177 to 185 inclusive, or any other law for the time in the course be inquired into or tried within such jurisdiction, but is under some law for the time being in force, tried in India. That cannot be tried by the court from as per the provisions of section 177 to 185. What is to be tried? That person is to try under some other law which is forced tribal in India. Then such magistrate may inquire into the offence as if it had been committed within such local. Then such magistrate will inquire into the offence as if that offence has been committed within the local jurisdiction of such magistrate, and compel such person in the manner herein provided to appear before him. The magistrate may compel such person to appear before him and send such person to the magistrate having jurisdiction to inquire into or try such offence. That magistrate may send that offender to the magistrate who is competent to inquire and try such offence. Or if such offence is not punishable with death or imprisonment life, such offence is not punishable with imprisonment life or death, and such person is ready and willing to give bail to the satisfaction of the magistrate acting under, and such person is willing to give bail bond for his appearance, take a bond with or without sureties for his appearance before the magistrate having such duties. Now section 87. What is section 187 provides? The magistrate sees, what he sees, reason to believe that any person who is within his local jurisdiction and that person has committed an offence outside his local jurisdiction, either in India or beyond India, and he cannot be tried by any court within the jurisdiction of section, and which that means outside an offence which cannot under the provision of section 177 to 185 both inclusive can be tried in court or any other law, but any other law for the time in force be inquired. What he says, within his local jurisdiction has committed an offence such jurisdiction, whether within or outside India, an offence which cannot under the provision of section 177 to 185 or any other law for the time in force be inquired into or tried within such jurisdiction. He cannot be inquired into or tried within such. But he is under some law for the time in force triable in India. He cannot be tried as per the provisions of the CrPC from within the provisions of section 177 to 185, both inclusive, and but on any other, but he should be tried by any other law. Then within such local jurisdiction, within any other law which is time in force, then in such case, the magistrate have power to summon that person, to that is within such local area, and compel such person to appear before him and to send him, remand him to custody and send him to the court which is competent to take cognizance of the offence. Or if the offence is not punishable with death or imprisonment for life, he may take bail bond from that person. When there are more magistrates than one having such jurisdiction, and the magistrate acting under this section cannot satisfy himself as to the magistrate to or before whom such persons should be sent. That means, as per section 127, that will be sent to a magistrate for trial who is having jurisdiction. When there are more magistrates than one having such jurisdiction. Suppose there are more magistrates than one having such jurisdiction to take cognizance acting under section. And he cannot himself, then the magistrate acting under this section, that the magistrate was completely attendance of that person, is not satisfied himself as to which magistrate or to or before whom such person should be sent or bound to appear. The case shall be reported for the orders of the High Court. In such case, the magistrate will obtain order from the High Court to which of the magistrate the accused will be sent. 188 offence committed outside India. When an offence is committed out of India by a citizen of India, whether on the high sea or elsewhere. What is high sea? On high sea, that is no man's land. So here, citizen of India, he committed an offence outside India. When an offence is committed outside India by a citizen of India, whether on the high sea or elsewhere. On the high sea, if it is committed or elsewhere. Or a person not being a citizen on any ship, aircraft registered area. The person who is not a citizen of India, he commits any offence in a ship or aircraft which has been registered in India, he may be dealt with in respect of such offence as if he had been committed at any place within India at which he may be found. Wherever he is found, then it is to be treated as if he had committed that offence within the territorial jurisdiction of that particular court. Where section 188 provides, when a person, when any citizen of India, he had committed an offence, IC or elsewhere, even beyond India, or in abroad, or a citizen of, or any other person, he may not be a citizen of India, suppose a citizen of a foreign country, not being such citizen, on any ship, he had committed any offence in any ship or aircraft registered in India. So there, he may be dealt with respect of such offence. He may be dealt with respect to such offence as if he had committed that offence in a place where he was found. Provided that notwithstanding in any of the preceding sections of this chapter, no such offence shall be inquired into or tried in India except to the previous sanction of the central government. Further, rider is there. That means he may be tried by a court where he was found, as if he had committed a but the sanction of the previous sanction of the central government is required. Receipt of evidence relating to offence committed outside India. Suppose an offence is committed outside India, how that evidence will be taken? Where any offence alleged to have been committed in a territory outside India is being inquired into or tried under the provision of section 180. 188 is very important provision. You should understand. Suppose a person has committed an Indian citizen, he committed a murder, suppose on high sea, or elsewhere. IC or elsewhere. Elsewhere means suppose in England or in America. He has committed a murder. He is to be tried. Suppose he was found at Rajasthan at a place within the jurisdiction, suppose a Jodhpur court, or suppose in Cuttack or in Bhubaneswar, he was found. Then he may be tried in Bhubaneswar court as if he had committed that offence. In such case, how evidence will be taken? This section 189 provides, where any offence is alleged to have been committed in a territory outside India, and is being inquired into or tried under the provision of section 180 and is to be inquired or tried as per provisions of 188, the central government may, if it thinks fit, direct that copies of deposition made or exhibits produced before a judicial officer in or for that territory or before a diplomatic or consular representative of India in or for that territory shall be received as evidence by the court. The central government, if it thinks fit, direct that the copies of deposition made or exhibits produced before a judicial officer in or for that territory, in that territory where the offence is committed, or for that territory, or before a diplomatic or consular representative of India, if any deposition has been given, or for that territory, shall be received as evidence by the court holding such. That shall be received as evidence by the court holding such inquiry trial. In any case in which such court might issue a commission, if in any case such court might issue a commission for taking evidence. That is, the court may issue a commission for taking evidence. Whatever deposition is taken by any court in that territory or by the consular representative of India, then that may be taken as evidence as when the state government thinks fit, the central government thinks fit, it may direct such deposition may be taken as evidence. Then evidence by the court holding such inquiry or trial in any case in which such court might issue a commission for taking evidence, or trial in any case in which such court might issue a commission for taking evidence as to the matters to which such deposition or exhibits relates. This chapter sometimes creates a confusion unless you fully understand the provisions. There may be difficult to you answer the questions. What is the place of that? Particularly some certain questions which are that case comes in sometimes as a problem in a manner, in a problem it is put in a question in the question paper. If you are aware of the provisions, you can answer this. What is this? This chapter we have concluded the jurisdiction in the criminal courts in inquiries and trial. In the next class, we will discuss the provisions in chapter XIV. Thank you.